Selamat siang, Mem Ayu. Untuk kelompok satu dari rombel 4, hari Jumat sudah siap untuk penilaian mood court.
Ya, silahkan.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. And I'm Ayu, present in third time in the mood court assessment of these courses today. We are from group 1 with me, Salazar, the third in the mood court. Next to me is Masawi Giuseppani as the third officer. And in the front of us is the LP, the judge, Ferguson Chelsea as member judge, Nyla Zaskia as the public prosecutor, Pina Sunoso as the legal counsellor, Alicia Zena as suspect, Ursula Bedi and Dimas Karmalati as witnesses from the public prosecutor, Sabrina Iza and Mohammed as witnesses from the counselor, and the last one is Rebecca Yosefiri as the victim in this one court. It started with the victim going to a regular internet cafe by winning motorbike that was close to the victim's house. After finishing, when the victim was paying in internet cafe fee, the victim saw that his motorbike had been taken and the victim tried to chase him. But the perpetrator dropped the motorbike very fast, so that the victim could not catch up. The penetration number 3 the console and clearly imagine if the trainer does controls of particular code and then are request to listen and the panel of the sensors if are requested to accept. During the process must be politely and orderly in place. Order the person and physical are from 15 minutes now are making us stop the course of the trial. Are request to show respect to the court. It is prohibited to bring fire up, to pose explosive or affected later for those who break them. Sit them with the officer. Anyone who does not behave appropriately does not obey the rules, and after this form, by the chief judge, it violates the rules of procedure, that the person concerned can be removed from the courtroom. Thus, the court rules please pay attention. Trial case legislation number 3, 2024, the panel of judges will end courtroom. The audience is set. The audience is asked to sit down.
Before the court begins, visitors are asked to turn off communication device and not the disrupt this court. How is the prosecutor? Is the legal counsel ready? Okay. The continuation of the Rapidos District Court criminal case court, which examined and tried the criminal case number 3, 2018, with the defendant Edisi Zena declared open to the public. Okay, public prosecutor, please bring the defendant to the courtroom. Okay, Mr. Yusuf and Matt, please sit down. We will continue our court with examination of the evidence and witnesses to the public prosecutor. whether they are ready with evidence and witnesses. Okay, how many witnesses will be presented in this court to the public prosecutor? Please present witness one and to the defendant is sitting next to his legal counsel.
Let's bring the witness.
Are you how physically and mentally how to attend this court? Yes, precious. Sit down. Please. Okay, can I see your identity papers? You can go in your. Before you give evidence at this conference, according to the law, you must swear and to or promise first for that. Are you ready to be sworn or promise? I am willing to be sworn, Your Honor. To the clergy officer to take their place.
All my works. By God I swear
By God, I swear
that I will explain
that I will explain
and trust nothing
in short nothing other than truth. My God. Witness, I have promised according to your religion, according to you, for that reason, we hope that you can provide correct information. Because if it is proven that you have provided false information, then you can be treated with a maximum prison sentence of 7 years, as regulated in Article 242 of the Criminal Code. Do you understand this? I understand, Your Honor. First, I will ask for your identity. Name is Navindo Intio. Place date of birth is at Bukati. The gender is man, 25 years old. Religion is Christian and live in Semarang. Work as employed in the corporate and nationality is Indonesian. Are you related by blood relationship employment with the defendant? No, Your Honor. Do you know the defendant? No, Your Honor. Witness, do you know what the case is related to? You examined in this conference? I know, Your Honor. Regarding to that, my motorbike. Please ask the witnesses, public prosecutor, legal counsel, and defendant to come forward to check.
Well, I would like to ask for permission for presenting evidence in the form of vehicle plates and letter T case. Is it true that the license plate number belongs to you?
Yes, the motorbike is my own motorbike, Your Honor.
When and where did you find out about the Vario motorbike your number police H 6965 PS has been lost?
After I finished at the internet cafe, home and I see someone took my picture. This was parked in front of the internet cafe. I went on the case again, but they didn't get stopped.
According to your knowledge, how many people are there bringing your motorbike?
I only saw one person.
Did the witness see or know the characteristic of the bringing your motorbike?
I saw the riding the motorbike leaning upon him. There are tattoos on his face, right arm. But another person is wearing a jacket, but his face is not visible.
Since you found out about the loss of your motorbike, was there any information other items lost or damaged?
There is prosecutor. The CCTV in the internet cafe parking are broken.
When you left the motorcycle, are you sure that it was locked?
Yes, when I was parking the motorcycle, I looked for the door or neck first.
In response to the prosecutor question, are you sure that it was the defendant who stole the motorcycle? Because you said he was wearing a face helmet, and the other person was wearing a jacket, but his head was blurred.
I did not see the defendant face, but I knew that he had a tattoo on his right arm.
But there are many people who have tattoos on their right forearms. Why are you sure that they stole the motorcycle?
I believe that the size of the tattoo is almost 1 inch and the color is black. But I recognize the tattoo on the right leg.
But there are many people who have tattoos on their left arm. Why are you confident that the person was doing that?
I am sure because the tattoo size means it was about one span of a hand and the color was black. Alright, the witness testimony is vehement substance. And we thank you. If we need further clarification from this witness, we hope that you will be available for another hearing. We ask you to return to the waiting room, prepare our witnesses without conversing or interacting with others. Prosecutor, please presenting the first witness.
Yes, Your Honor. I would like to present the first witness unto the witness.
Are you in good physical and mentally condition and ready to provide testimony in this court? Right, please show your identity. You can go and check. Based on the law, for before providing testimony is closed. You are a lawyer, for according to your ethical belief, are you ready to be sworn in? Officer, please write the witness in taking their sword.
I swear by an outline. I swear by an outline. That I will testify the truth. But the truth, nothing but the truth.
Witness, you have sworn by faith. We hope that you will provide truthful testimony, because if proven otherwise, you may face imprisonment for up to 7 years, as states in Article 242 of the Indonesian Penal Code. Do you understand?
I understand, Your Honor.
Okay, first of all, I'm going to ask you for your identity, and I'd like to you answer clearly. Name is Silamni. Place of birth in Tasikmalaya, December 2, 28, 26, 2001. The gender is female, 24 years old. Religion is Islam. Live in Semarang. Work as a housewife. Nationality is Indonesian. Witness, do you know the defendant? Witness, are you related to the defendant and do you have work relationship with the defendant? Witness, do you understand why you are being asked to testify as a witness in this court?
I understand, Your Honor.
Yes. Will the public prosecutor ask the witness any questions?
The witness in the face of the perfect paper. But in my mind, after personal contact that someone had fixed this motorcycle, I immediately took the initiative to look at the CCTV in the parking lot of my car. So the CCTV was the face of the people. Yes, the immediately showed the perfect version was for a few seconds, but not long after that my CCTV suddenly went dead. How did the defendant damage your CCTV? In the CCTV, I saw the professional looking person and naturally ignored my CCTV. Well, thank you. Usually, please ask permission to present evidence in the form of CCTV camera footage.
Please ask witness, prosecutor, legal counselor, and defendant to come forward to examine the evidence in the form of CCTV footage.
Thank you, Your Honor. When a criminal opens the doors, where are you? I was already at the interview. Has there ever been a thing that is before. The person will be just like this. When the fit occur, what your internet traffic or not? I'm so much. My cafe was always crowded. You already know that. Your cafe is always crowded. Why did you bring a party and to make it free? I have been substituting in parking lot. So I don't think it is necessary to make a party. Where there are any other atmospheric problems? Your Honor, that's enough question.
The testimonies, the witness is considered substance, and we thank you. And if we need more information from the witness, we hope that the witness will not object to coming back to this court. Please go to the place provided and do not talk to other witness or experts. Prosecutor, please present the witness.
Your Honor, officer, police present the second witness on the top. Because
Are you physically and mentally healthy? Needs testimony in this court.
yes, Your Honor.
May I see your evidence card? Before you give testimony in this court, according to the law, you must first take a sword or and not are you willing to take a sword or
I am willing to be sworn, Your Honor.
to the clergy to take their place?
I swear that I will testify fully and no other, truthfully and in no other. Well, in the truth, my will help me, my God help me.
For the reasons, we hope that you can provide true testimony, because if it is proven that you have provided false testimony, then you will be punished with imprisonment for up to 7 years, as stipulated in Article 242 of the Indonesian Penal Code.
I understand, Your Honor.
Okay, first of all, I will ask your identity and I ask you to answer clearly. Name is Diva Skarmati, place of birth in Sumedang, February 2000. Gender is female, 24 years old. Religion is Islam, live in Semarang, work as police investigator. Nationality is Indonesian. Do you know the defendants?
Yes, Your Honor.
Witness, do you understand why you are being asked to testify? Witness in this court.
Yes, I understand, Your Honor. In connection with the crime of theft and the investigation that I conduct against the defendant.
Okay, please allow the public prosecutor to ask questions.
Your Honor. No, is it true that you conduct the examination of the defendant? Yes, I conduct the examination. Did you use pressure or harshness during the examination process? No, ma'am, we do not apply any pressure or harshness during the examination. We conduct the examination in accordance with the applicable SOP. After arrested the suspected perpetration of the theft and zina, do you know the role of each of the suspected is playing? The results of the examination of the perpetrators is not play a role. Executor when committing theft, who had a regulated decay and jockey or who drove the goods of crime, monitored the situation around before he stole the motorcycle. We have enough questions.
Next, is there anything for the legal counsel press?
Yes, Your Honor.
Please convey the legal counsel.
Witness, when did you examine the defendant? Yes, Your Honor, I examined the defendant on Tuesday, October 16, 2024. During the examination, did the defendant provide the testimony and was there no information? Yes, Your Honor, the defendant testified correctly and without intervention. Did the defendant acknowledge his action during the examination? Yes, the BIP said that the defendant has acknowledged his actions. Mr. Honor, our questions.
The testimony of the witness is considered subject. We thank you, and if we need further testimony from the witness, we hope that the witness will not object to coming back to his court. Please, the witness, go to the place provided and do not talk to other witnesses or next to the legal counselor. Are there any witnesses present in mitigation of evidence?
Yeah, we will present two witnesses too.
Are the witnesses ready? And if they are ready, please present them.
Already, Your Honor. Officer, please present the first witness on the of 679.
Are you ready and mentally healthy? Okay, let's take my notes. Okay. Before you give testimony in this court, according to the law, you must warn and promise in advance. So are you willing to be sworn to the clergy take your place?
By God, I swear that I will truthfully, I swear that I will truthfully explain nothing other than, nothing other than the truth.
You have sworn according to your religion, or we expect you to give a true statement. Because if it is proven that you give a false information, then you can be punished with imprisonment for up to 7 years, as stipulated in Article 242, the Criminal Code, 200 of 2042 of the Criminal Code. Do you understand?
Understand?
All right. First of all, I'm going to ask your identity. Name is Sabrina Isra. Place date of birth at Jakarta, 20 June 2002. Gender is female. 22 years old. Religion is Islam. Live in at Gajah Mungkur. Work as engineer. Nationality is Indonesian. Do you know the defendants?
Yes, Honor.
Are you related by blood and occupation of the defendants?
No, sir.
Okay, please allow the legal counsel to ask questions.
Thank you, Your Honor. Witness, how close is your relationship with the defendant? My relationship with the defendant was stated that on further because the defendant often showed up at mass. When the death occurred, did the defendant make the witness? No, ma'am. But it's clear is that the defendant wanted to borrow the key. Did you lend her the key? No, ma'am, because I didn't have the little key. Did you know about the technique by the defendant? Yes, ma'am. I just found out about this and I was surprised because when my knowledge of the religious of 7% in the village, she is an asked person in a social. That's in my command. Thank you, Your Honor. Say, you said the defendant was a customer, right? What do you know about the economic condition of? Yes, it's not wrong, mom. We don't get calling money. At my shop, the defendant often of me, but the defendant was solicited to buy out that money. Witness, in your village, has there been any previous case of that? As far as I know, there was a fragment of the defendant was in our village. In a city.
Witness, do you wish to add a further defense?
Okay, Honor, because it didn't was something construction, it didn't be anything show in the company. I checked when my employees are returned to the next residence.
Okay. The witness statement is then substance, and we thank you if we are required further in testimony from the witness. We hope you will be available. We ask that you return to the witness waiting room without conversing or interacting with others. Please, legal counsel, please presenting the second witness.
Ya, terima kasih, officer. Please, by the name of Muhammad.
Physical and mental condition and ready to provide testimonies. Please show your identity. Before giving testimony in this court, you are required to take a sword according to your religion or belief. Are you ready to take the sword?
I'm ready, Your Honor.
Officer, please guide the witness in taking their part.
And not
Witness, you have sworn by faith. We hope you will provide truthful testimony, because if provides otherwise, you may face imprisonment for up to 7 years, as stated in Article 242, the Indonesian Penal Code. Do you understand?
Yes, I understand, Your Honor.
All right. First, I will ask your identity. I request that you answer clearly. Name is Muhammad Lutfi. Place and date of birth at classified in August 2000. Gender is male. 24 years old. Religion is Islam. Live in Pegunungan. Work as employee in the corporate. Nationality is Indonesia. Do you know the difference?
Yes, I am Indian.
Are you related to the difference?
No, Your Honor. I am not neighbor of the defendants.
Please legal counselor to ask questions.
Thank you, Your Honor. Witness, are you aware of the defendant's daily activities?
I know that the freedom does not record crimes. Sometimes participate as for project level. And the defendant is not proper. Because I see that when he comes for from project, he immediately looks for additional work, such as according revenue.
When did you know? Where did the defendant go?
I know that she is working the afternoon in the night. I don't know it's work. But I have done to say no before the incident.
Explain where there was a case of the witness. Where were you?
I was constantly there, and then there was the defendant was trying to correct that. I explained to then I said we want to play.
Have you ever noticed any suspicious behavior from the defendant? Witness, I haven't found any suspicious behavior from the defendant. Witness, did you know that the station was going to commit an act of theft? Number one.
Well, the testimony from the witness is considered substance, and we thank you. And if we need testimony from the witness again, we hope that the witness does not mind being back to this trial. Please go to the place that has been provided, and do not talk to other witnesses or experts. Thus, today trial is postponed for 1 week for 7 days from now. What date?
Friday, 9th July 2024, Your Honor.
Okay, With this, the court is postponed for Saturday and will be continued Friday, July 26, 2024, with the agenda of 11 extension trial.
The judge left the courtroom and the audience was expected to start. Am I? Permisi, Mem, untuk kelompok 1 dari rombel 4 hari Jumat sudah menyelesaikan mood court-nya, Mem. Permisi, Mem.
Oke, ya. Applause untuk kalian semua. Baik sekali. Dalam presentasinya menyiapkan memboard juga ya. Jadi sudah baik, sudah saya cukupkan untuk kelompok satunya. Tadi audionya juga terdengar. Sekarang lanjut ke kelompok 2.
Baik,
Gitu.
Mem. Terima kasih, Mem.
Ya. Kalau laptopnya masih mau digunakan, minta kelompok 2 untuk ganti laptop ya.
Satu, dua, tiga. Thank you.
Ya, you're welcome. Oke, have a nice weekend ya. Hati-hati pulangnya. Ya.
Ya, baru. Ini gimana?
Mohon maaf, Ma'am. Kami sudah siap, Ma'am.
Ya, silahkan langsung dimulai.
Terima kasih, Ma'am. Now, process. All participants, please ensure your materials are ready. The Honorable Judge Michelle Turner will arrive in two.
The hospital does pick out from society. Now, this is a matter of that. Everyone here, but I don't know. Please be seated.
This is case number 2024 CP 98765. State of California versus Alexander Mono. Involving charge of first degree murder.
Court is now in session. This is the case of State of California versus Alexander Mono. The defendant is charged with the murder of Charles Mono, her husband. Ladies and gentlemen of the jury, your role today is to determine whether the defendant is guilty or not guilty of the first degree murder. You are to consider only the evidence presented in this courtroom and follow the law as I instruct. Prosecution, you may proceed with your opening statement.
Ladies and gentlemen, jury. Today, we will show you that Alexander Mono is guilty. Dated murder. Charles Monroe is a loving father, successful businessman. Second, he is not sure in his own role. The evidence will show that Alexander Monroe killed her husband, 20 pounds and bound. You will hear testimony from Marcel Monroe, Charles' son, and the defendant's stepson. Will explain toxic diagnosis in their household. Marcel will testify about Alexander's growing hostility toward her and culminating in this violent act. The forensic evidence will show that the fatal blow was delivered with deliberate force, and with an intentional act. Additionally, financial courts will reveal that Alexander stood to pay $2 million from her husband's life insurance policy. Also, he preserved him for the update just months before his death. By the end of this trial, the evidence remained no doubt that Alexander Monroe fled. We'll ask you to return to work.
In fact, your opening statement. Ladies and gentlemen of the jury, this case is not as simple as the prosecution have you believe. Alexander Monroe is not a murderer, he's a victim. For years, Alexander entered emotional and psychology from her husband Charles Monroe. In the night of his death, Charles attacked Alexander in a fit of rage, taking out of it for her life, creating the nearest objective to defend herself. The prosecution will point to like insurance policy as motive, but the evidence will show that Alexandra had financial struggles and no reason to harm her. We will also hear from an expert in domestic violence who will explain the psychological toll of years of abuse and how it can get a victim to act in self-defense. Finally, we will address the testimony of Marcel while we sympathize with the loss. Earliest relationship with Alexandra has been great from the beginning. Her testimony is colored by years of resentment, and we urge you to wait carefully. By the end of this trial, you will see that Alexander Monroe acted in self-defense. You are still fine, but not you. Thank you. Prosecution. You may follow your prosecution.
You should call Marcel Monroe next time.
Thank you.
Begin.
Never got along. It's always seemed like she didn't move around like I was in the wood.
That's true.
No. If anything, it got worse. He became more distant and started over especially with Major.
It will be hard. Right from the top.
They argue a lot about money, mostly. She was mistake of being controlling and giving her what she wanted. I heard that she ended lately more than this month. Yes, he told me he was worried about how angry she had been. He said he didn't know what she might do if things got worse.
Let's talk about the night of the incident.
That's it. Yes, I heard shooting. It sounded like they were fighting again.
Could you recognize the voices?
Yes, it was my dad and Alexander. I heard a loud crash and something heavy is falling. That's when I ran downstairs. My dad was lying on the floor in the gym. He wasn't moving. Alexandra was sitting over him holding a dumbbell. Yes, she said, it's not what it looks like.
Can you describe her dramatic situation?
She looked panicked, like she was trying to explain, but I didn't believe her. I knew what I was seeing.
You said you knew, of course.
Because she was standing there with the dumbbell in her hands. My dad was on the ground. There was blood everywhere. It was obvious what had happened.
That night, did Alexandra ever express fear of her father or suggest it? Violent.
No, never.
Did you ever witness your father being physically abused before Alexandra?
No. My dad could be angry, but he wasn't violent.
See, it's.
No, he always looked fine to me. Third, you just divide. Your relationship with Alexander. Your stepfather was straight. Is that correct? Yes, that's correct. Would you say that household unit existed from the beginning of her marriage to your father? Yes, we never got along. And in your opinion, the strained relationship was mutual? Yes, it was mutual. Mr. Mundo, do you think it's possible that your negative feelings toward Alexander may have influenced how you perceive marriage or relationship? Speaking on the night of your father.
Objection, Your Honor. Question calls for that.
Sustain, also, rephrase your question. Mr. Mundo, on the night of your father's death, you just give it to your child. Alright, yes. And when you were closer, you saw your father in light the floor and Alexander standing near him with the lumber. Is that right? Yes. Did you actually see Alexander strike your father? No, I didn't see the moment it happened. So you didn't witness the interaction between Alexander and your father leading up to the fatal blow? No, I didn't. Yeah. You just admit that you knew Alexander had killed him. Can you explain how you reached this conclusion without witnessing it?
Objection, Your Honor. The question.
Overall, the witness man. I mean, it was obvious. She was standing there with the dumbbell, and my dad was on the ground. What else could have happened? Mr. Bro, I understand how upsetting that moment must have been. But would you agree that deception met in the heat of the moment might not always be correct? I guess it's possible, but I know what I saw. Mr. Monroe, you just even relate that your father and Alexander often argue about money. Is that correct? Yes, they argue a lot. And you mentioned that Alexander had treated to leave your father on more than one occasion. Yes. Would you say that your father also became angry during this argument? Yes, he could be angry. Did you ever witness your father raise his voice or toward Alexandra? I heard them yelling sometimes, but I didn't see him hit her or anything. Mr. Monroe, would it surprise you to know that Alexandra with instead of psycho energy or professional activities, including being shown to perform very
Just in your own.
sustain. Also, move on. Mr. Monroe, you investigated the epic shooting before the incident. Did you even recognize father voice during the shooting? Yes, it was him. And would you describe his tone as calm or angry? He sounded angry. Thank you, Mr. Monroe. For the victim.
Suppose a 50 friends with a over by earlier that you heard an argument between your father and Alexander before you came downstairs.
That's correct.
And you stated that your father sounded angry. To elaborate on what.
I heard them yelling at Alexandra. I couldn't make out everything, but it sounded like they were arguing about a new bit. His tone was loud and yes, but she wasn't as soft as my dad. It sounded like she was trying to defend herself or arguing, but he was definitely louder. Yes, I do.
How close was she to your father's daughter than himself?
So I was right next to him, just a few feet away.
And what Alexander said, what did she do?
Said, it's not what it looks like.
Not only did Alexander offer an explanation for
No, she didn't explain anything. She just kept repeating that it wasn't what it looks like.
that sounds in your assumption, well, based on everything you saw and heard that night. Oh, yeah, like the loud action. Alexander was standing over his body, holding the dumbbell. He felt that Alexander. Weeks or even months leading up to your father's death, did you see or hear anything that suggested Alexander was in danger or fear for her life? Thank you, Mr. Monroe, no further question. You. One, the average murder report on 20,000 arrests has been submitted for. Ladies and gentlemen of the jury, the evidence we are about to present, there are reasonable doubt that Alexander she killed last thousand more. First, let's examine the murder of 20,000 dumbbell of the confirmed that the blood on the dumbbell matches from the skin. This not were consistent with the charge indicating she built the weapon with skin force. The autopsy reports revealed that Charles Monroe suffered a single fatal blow to the back. The medical examiner determined that reports immediate unconsciousness and death. The blow shown here consistent with the attack behind the victim was either seated or crouched. This contradicts the defense claim in self-defense as it suggests Charles Monroe was not active at the time of the strike. Let's discuss the life insurance policy. Financial reports show that just 6 months before Charles' death, Alexander Monroe convinced him to update his policy, increasing the payout to $2 million and naming her as the sole beneficiary. This sudden change raises serious questions about her motives. Combined with the forensic evidence, it's clear that this was not a spontaneous act of self-defense, mediated crime. The evidence speaks for itself. Alexander Monroe had the motive, the opportunity, and the means to kill her husband. Thank you.
Ladies and gentlemen of the jury, while prosecution evidence may appear compelling at first glance, it does not tell the full story. This is not a case of premeditated murder, it is a case of survival. To understand Alexander Monroe's action, we must consider the years of abuse he endured, the demands of childhood. The evidence called for the daughter to get out. Also, another matter. Doctor, thank you for being here. Good afternoon. Can you please state your qualification for the court? I am a patient clinical psychologist with over 15 years of experience specializing in trauma and domestic violence. I hold a PhD in clinical psychology from Stanford University, and I work extensively with survivors of abuse in both clinical and forensic settings. I also published several papers regarding articles of the psychological effect of long-term domestic abuse. Thank you, Dr. Based on your expertise, can you explain in detail what constitutes domestic violence? Certainly, domestic violence involves a pattern of behavior in which one partner exerts power and control over the other through psycho, emotional, psychological, or financial abuse. This behavior often escalates over time, leaving the victim feeling trapped and unable to escape. In your experience, how does prolonged exposure to domestic violence affect a person psychologically? First, exposure to domestic violence can lead to a range of psychological effects, including anxiety, depression, post-traumatic stress disorder, and what is known as battery moment syndrome. Victims often develop hypervigilance, meaning they are constantly on edge and highly sensitive to perceive a threat. Over time, this can improve their ability to access the interrational, leading them to act instinctively in moments of perceived danger. Could you elaborate what Miller common syndrome is and how it relates to post-traumatic stress disorder? Whether common syndrome is a subset of PTSD, it is basically applies to a victim of domestic violence. It involves a cycle of abuse where the victim experiencing violent of tension, violent outburst, and reconciliation of time. The victim may feel hopeless, believing there is no escape from abuse. This psychological state can lead to identity, fight or flight response, where the victim may react eventually, defensively, to even a minor trigger or a threat, presenting them as a life-threatening. Let's turn to your evaluation of Alexander Monroe. Did you have the opportunity of meeting with her and assess her at political scale? Yes, I conducted several interviews with Ms. Monroe following her arrest. I also reviewed her personal history and accounts of her relationship with Charles Monroe. And based on your evaluation, did you find evidence that Ms. Monroe exhibited signs of benevolent syndrome? Yes, I did. Ms. Monroe described a long story of emotional abuse and control by her husband. She also reported specific incidents of psycho violence, including being pushed into a wall during an argument and having conflict thrown at her. Her other were consistent with the psychological profile of a domestic violence victim. Dr. Bennett, How did Miss Monroe experience with domestic violence in her birthday? The name of the incident. Miss Monroe described being trembled and terrified during the argument that he would be hurt to death. Based on the psychological profile, it is clear that she presided in life in immediate danger. Her actions that night were consistent with someone experienced either fight or flight response, acting instinctively to protect himself. Prediction as a review. The father Charles Monroe was injured and previously professional opinion. Is it possible to be fighter? Yes, absolutely. When a person is in a state of panic, their action may appear calculated, but they are often driven by instinct and fear. The brain focus in such a moment is survival, not rational decision making. The purification has pointed out that this model will have physical injuries or ultimately destroying properties. In your experience, is there unusual for victims to domestic violence? No, it's not unusual at all. Many victims do not report abuse to authorities out of fear of relation. They or believe that they won't be believed. And additionally, emotional and psychological abuse often lead no psychological. Whereas a effect can be just imaging a cycle in violence. Dr. Bennett, some may argue that these murder could have signified that during the future. How would you respond to that? Living an abusive relationship is far more complex than it appears from the outside. Victims often face financial dependence, fear of harm, or manipulation that makes them believing if it's possible. In this moral case, he described feeling that any action to lead will escalate the abuse of the life in danger. Finally, in your professional opinion, do Alexander Norris action on the night of the incident aligned with the psychological effect of the person receiving you? Yes, they do. Here description of your fear, his protection of immediate danger, and here instinctive reaction are all consistent with the behavior of someone who has endurance fear of abuse and acted in self-defense. Yes, that is correct.
And base this conclusion.
Yes, I interviewed you multiple times following the arrest.
Well,
Yes, I'm aware of that. However, there is a common conflict of abuse to avoid reporting incident due to fear of shame.
your conclusion ran entirely on the first word.
Okay, good. The question is argumentative. I ask you to fix not the counsel. Please raise your right.
Documented without corroborating evidence. How can we be certain that it is Ms. Monroe described?
Online professional training and experience. Victor is often exercise consistent psychological and behavioral better and is moral according to its strength.
Please think, just
Objection, Your Honor. Call for speculation. Sustain. Counsel. Move on. Yes. Right.
report shows that Ms. Monroe was struck at the back while kneeling on the couch. Would you agree that this decision is juxtaposed not facing growth.
To action, sequence of events, victim of abuse often act in a state of panic. It is possible that if tomorrow frequently decide imminent threat even if Miss Morrow was not facing immediate moment.
Ladies and gentlemen of the jury, at this minute she cannot confirm of what happened. Is it true, Dr. Bennett? About Miss Monroe's actions that have making face with
Objection, Your Honor. The prosecutor is stating sustain, counsel, turn it down.
Bennett, you mentioned earlier, convict and receive minor threats, is that correct? Then that also mean Miss Monroe misinterpreted her husband's actions that
It's possible. When the context of long-term abuse, make a subtle reaction understandable and if any can avoid it.
justification for Miss Monroe's actions.
Yes, that is correct. My role is to provide context, not to determine will ultimately.
That's not again. Reality of the field. Alexander Woodward, acting in a moment of terror, not the least. We wish you to consider her action in context of her lived experience. Both sides have presented their case. We will now hear closing argument.
Gentlemen of the jury, evidence
We ask you to find her not guilty. Members of the jury, you will now be obeyed. The bailiff will escort you to the room. But now, members of the jury, have you reached a verdict?
Yes, Your Honor, we have.
Please hand the verdict form to the bailiff.
In the case of State of California, Mr. Monroe, the jury find the defendant guilty of first degree murder.
Order. Mrs. Morrow, You have been found guilty of first-degree murder. It is one of the most serious charges in our justice system, and it carries significant consequences. Before I proceed, I will give both parties an opportunity to make an immediate statement regarding today's prosecution. Would you like to address the court?
Your Honor. This verdict reflects the strength of the evidence and the diligent work of the jury. Justice has been served for Charles Rowe, a man whose life was taken in cold blood. We understand that this case has been emotionally charged for all involved, but the facts have still been clear. We commend the jury for being thoughtful in deliberation and trust his verdict will be established, especially Scott. It's that, Martha, thank you.
Defense, do you have any statement to make before we adjourn?
Yes, Your Honor. We deeply respect the jury's role in this verdict. The verdict believe its verdict does not reflect the full truth of Alexander Monroe's shooting. It is not a cold-blooded kill. It is a victim of fears of abuse, but it is a moment of fear and inspiration. We intend to hear all available evidence, including an appeal to ensure that Miss Monroe story is fully heard. We maintain our position that is was a tragic act of self-defense, not premeditated murder. And
Mrs. Monroe, before I answer the next step in this case, do you wish to address this court? Court acknowledge the emotional weight of this case is very difficult to present for everyone. However, the jury has rendered its decision, and this court is bound by their verdict. You will remain in custody until your sentencing hearing, which is scheduled for 2 weeks from today. At that hearing, the court will consider arguments from both sides regarding the appropriate punishment, which may include life imprisonment without the possibility of parole. Court, please confirm the next steps. Ensure all materials are entered into the
Your Honor, verdict of guilty will be entered into the optional number 2024 98765. And this has been scheduled for January 5th, 2025 at 10 a.m.
Thank you. Wait, please take the attendance into the file. Court is adjourned.
Ma'am, kita sudah selesai, Ma'am. Permisi, Ma'am. Nggak tahu, saya nggak ada buku. Ya udah, konfirmasi langsung lanjut aja, Ma'am.
Oke ya, tadi saya sedang, halo kok sudah bubar? Halo, suara saya kedengaran nggak ya? Halo, suara saya kedengaran? Oh itu kalian masih di mute. Mana kelompok 2 kok sudah bubar, padahal belum saya izinkan.
Permisi, Mem, tadi sudah memberitahu yuk.
Iya,
Kalau
saya,
dua sudah selesai, Mem.
ya harusnya kan nunggu saya dulu. Ya, saya kan main 2, main tim sama main Zoom, main Jimmy. Jadi misalnya saya tidak langsung merespon, saya sedang memberikan informasi ke rombel yang lain, seperti itu. Dari pagi kan sampai sekarang belum selesai. Ada 3 kelas, tapi ya sudah, enggak apa-apa. Ini berarti kelompok 3.
Iya, Mem.
Ya, silakan prepare nanti. Jangan sampai ada yang blocking seperti kelompok 2. Kelompok
Iya.
2 tadi ada yang blocking. Kalian kan bisa melihat, di situ kan sudah terhubung dengan TV. Kalian bisa melihat tampilan di saya seperti apa. Atur aja. Jadi hakim itu nggak harus di arah yang tembok kipas angin, boleh di arah yang jendela, boleh di arah yang samping. Semuanya pastikan ketika ngomong saya bisa melihat. Tadi kelompok 2 banyak yang blocking. Nggak jelas saya kelompok 2 tadi. Ya,
Iya, baik, Mem.
tahu blocking nggak? Membelakangi
Iya,
kamera.
Mem. Iya.
Ya, berarti
Iya.
kan itu. Oke, silakan persiapan. Dan nanti kalau sudah siap dan mau mulai, infokan kembali. Apakah jelas?
Jelas. Baik, Mem. Kami izin persiapan ya, Mem.
Oke, ya.
Ya, terima kasih, Mem.
Ini berapa?
Ya. Ada di mana ada slot? Ya, yang mana, Mak? Udah ya, berarti udah mulai ya. Baik, Mem, kelompok 3 sudah siap. Bisa yuk.
Oke, ya, silahkan dapat dimulai untuk kelompok
Oke.
3. Nah,
Iya, baik.
itu ada yang membelakangi.
Ini Sakti apa boleh madep ke kamera, Miss?
Boleh dong.
Boleh, oke baik.
Jadi itu kursi yang di tengah dikosongin aja. Rada ke samping gitu, itu Alvan, dan sebelahnya rada ke sana.
Berarti saksi tidak harus di tengah, nggak apa-apa?
Nggak apa-apa, nggak apa-apa.
Baik.
Karena nanti kasihan yang saya nggak bisa lihat, kan saya nggak bisa nilai. Oke,
Baik, kalau bisa, Miss.
ya geser sedikit. Oke,
Oke.
kan terlihat semua. Oke ya.
Ya, oke. Baik, terima kasih. Kami mulai ya, Miss.
Ya.
Assalamualaikum warahmatullahi wabarakatuh. Good morning. First study today's trial, I will read the trial code. The following are the code books that must be opened and and lead the room. Everyone present, stand, and respect. Second, during the trial, the visitor must sit collecting and orderly in their respective places and maintaining order in the courtroom. Third, practice and third visitor are required to wear appropriate and drinking, smoking, reading, newspaper, or taking action that could disrupt the proceeding. Fourth, in the courtroom, everyone is obligated to show respect for the court. Fifth, anyone is prohibited from bringing firearms, sharp weapon, explosive, or tool or object that can endanger the security of the trial, and anyone who brings them must deposit them in a place specially provided in the security section of the job that administrative laws. Six, taking photos, recording, sound, or television recording must first ask permission. Seven, anyone who permits himself in a from the court gives a warning but still violates the rules of procedure then by order of the chief judge. The person concerned is removed from the court, and if the violation of the rules of procedure in question is of a criminal nature, it also does not reduce the possibility of prosecution of the today, Friday, 20 December 2024, the criminal case trial number case 87 Artido or 8 or Devon or 2024 with the defendants Mahatma Mayo is ready to be. The federal judge will enter the courtroom. Defendants are asked to stand. The federal judge will enter the courtroom. Ladies and gentlemen, please stand up. Ladies and gentlemen, please sit back down.
Is the public prosecutor ready for the trial?
Yes, Your
Is the public defender ready to attend the trial
Yes, Your
on this day, Friday, 20 December 2024? The deposit court hearing which examined and tried the criminal case of the first instance nominal case Act 7395 7 Demo 2004 with the defendant Mahatma Mayo. I declare the prosecutor is requested to present the defendant in the courtroom.
The defendants are requested to enter the courtroom and are invited to sit in the places that have been provided.
Mister, do you speak English well? Yes, I can, Your Honor. Well, I will ask for the identity of the defendant as contained in the BIP. Please provide the identity card of the defendant.
Judge member, this is Your Honor.
Mister, what's your name? My name Mahatma Mayor. And where you place of your birth? I was born in Batam. And when you date of birth? I was born at 28 January 2000. And what's your gender? My gender is man. And what's your religion? My religion is Islam.
Mr. Defendant, are you in good health, both physically and mentally, and ready to attend today's trial?
Yes, I am in good health, both physically and mentally.
Are you defendant ready to attend the trial?
Yes, Your Honor.
You are charged by the public prosecutor with committing the crime of Article 340, which carries a sentence of 20 years imprisonment, life imprisonment, or death. Are you currently represented by legal counsel?
Yes, I am currently representing legal counsel that is Miss Felicia Purba.
Is that right, Mr. Felicia Purba, your legal counsel?
Yes.
Okay. The hearing will continue with the reading of the indictment by the public prosecutor. And you receive a copy of the indictment.
Yes, Your Honor.
Please allow the public prosecutor to read of the indictment.
The indictment number 49, criminal 2008 PN GMB, date December 20, 2024. Answer, letter of case of Depok District Court in Depok, West Java, Present. The public prosecutor and the Depok District Attorney's Office present on the result of the investigation, examination of this case, and decided the following indictment. Okay, Mahatma Mayu, place ended of birth, Batam, January 28, 2000. Gender, man, nationality, Indonesia. Address, Bahasa Prana Kompleks, Sarang Street, Lot G1, Sundar Agung Urban Village, Tanjung Priok, District North Jakarta. Then on July 12, 2019, and the Madura Street number 309, Depok, West Java. The defendant committed the crime of premeditated murder against the victim and also in a very cruel, sadistic manner. Chronology of events. First, at 1 p.m., the defendant invited the victim to his apartment on the pretext of a personal matter. Second, after the victim arrived, the defendant prepared the tools used to commit the murder. Third, the defendant then committed against the victim by stabbing and striking the victim with an iron rod. Fourth, the victim was dead. The defendant fled the victim's body using a knife.
Motive of crime. This crime was committed by the defendant because of his malicious intent and carefully planning to take the life of the victim due to delusion. The crime committed by the defendant is set out in Article 340 of the Criminal Code, premeditated murder. Article 338 of the Criminal Code on murder is required as a subsidiary charge. The evidence that was successfully found in the investigation is as follows. 1. Physical evidence. 1 iron rod, 51 centimeter long. 1 knife with a wooden handle. Piece of the victim body found at the scene. 2. Supporting evidence. Statement from the witnesses who saw and heard the incident. CCTV footage around the scene of the incident showing the victim's arrival at the defendant's apartment. Post-mortem from a forensic doctor explaining cause of the victim death. Based on the above, we request that panel of judge decide as follows. 1. declare the defendant Mayu legally right remaining murder. Two, impose the death penalty on the defendant in accordance with the provision of the 340 of the Indonesian Penal Code because his actions were painful and sadistic and had equal impact on the community. Thus, we make this indictment to be considered in the trial. We hope that the panel of judges can provide a fair decision and in accordance with applicable law, public prosecutor.
Defendant. Have you understood indictment read out by the public prosecutor? Yes, Your Honor. Mr. Defendant, will you file an objection to the indictment read out by the public prosecutor? I will repeat, and I will my Mr. Defendant, will you file an exception to the indictment read out by the public prosecutor? Are you ready to read your exception to the indictment read out by the public prosecutor?
In the of December regarding not of objection or exception to the public prosecutor indictment, where the undersigned named the District Attorney Office address 8739 7,123 President Attorney for Defendant Mahatma Bayu, acting for and on behalf Defendant Mahatma based on special power, Attorney dated 15 November 223, additional meaning, not of objection or exception to the public prosecutor indictment in criminal case number 449 PAD 208 PNGN with the following reason. One, introduction that based on the indictment that has been read by the public prosecutor on November 15, 223, we consider that the charge contained more formally imagined which result in the change they declared and void by law. Two, instead for exception, under a concurrent indictment, Article 143, paragraph 2 of the Criminal Procedure Code, the indictment submitted by the public prosecutor does not meet the format and actual requirement stipulated in Article 143, paragraph 2 of the Criminal Code namely, a complete identity of the defendant. In the indictment, there is no explanation regarding the defendant of person, which is one of the element of identity that must be included in the indictment. The description of the event is not coherent. The prosecutor did not clearly explain how the intended murder process took place, including the absence of a detailed description of the defendant's intent or mens rea. Two, element of regional urban, then the indictment said that the defendant violated Article 340 of the Criminal Code concerning premeditated murder, but the prosecutor cannot explain the element of claim. Person, in Article 340 of the Criminal Code, claim must be carried out carefully. The process state. However, the indictment only state that there was a bad intent without considering whether, when, how, and the claim was carried out. S5. The advice presented by public prosecutor is insufficient to support the indictment. CCTV footage only saw the victim coming to the defendant apartment without any advice that the defendant carried out the action as charged. Physical evidence, such as a iron bar and knife, are not clearly linked to the defendant. There is no forensic finds showing the defendant fingerprints or DNA on the item. 4. Regulating the defendant human rights during the investigation process. During the investigation process, the defendant rights can be violated, including legal assistance, was not provided when the defendant was questioned. There is an allegation that the confession given by the defendant was obeyed and unappreciated in mediation from the investigator. This believe in Article 117 of the Criminal Code. Application. Based on the description above, we request the Honorable Panel of Judges to consider and decide following matters. To declare that the public prosecutor in demand number 49 PAB 208 PN thus not meet the formal and the material requirements stated in the Article 143, paragraph 2 of the Criminal Procedure Code. To declare the indictment and void by law, to order that the defendant be released from the detention and his right restored. This submit this expression with the hope that the panel of judges can consider it peacefully and clearly. Therefore, November 15, 223, your faithfully, the defendant attorney.
Mr. Public Prosecutor, do you understand the defense counsel exception?
Mr. Panel of judges.
The hearing will continue with the explanation of the witness. Mr. Public Prosecutor, are you ready to present the witness?
Yes, the panel of judges will witness.
Yes. Please present the witness, Master Public Prosecutor.
Yes, the witness is Srikant and the courtroom.
Morning, Mrs. Smith.
Before giving testimony, is the witness willing to take an oath?
Please allow Judge Member One to take oath of the witness.
Bismillahirrahmanirrahim.
Bismillahirrahmanirrahim.
By Allah, I swear that I will tell the truth
With that, I will not have,
and nothing but the truth.
but
In giving his testimony in his trial, you must be calm, give testimony clearly and not be afraid. And you must give testimony about what you experience, but and show yourself without any pressure. Okay, I will hand over the examination process to the public prosecutor.
You know the defendant,
yes, I know. Mahatma related to the defendant by book, not another one.
what did the defendant
The defendant is not the enemy that was two papers. The prosecutor is Mahatma, who was very during the apartment to the violent and explain what took place. At the time, I was in a book, and I think with another man, Mahatma. Something about the actress went to go after that what's it better than the white and that doesn't sound. So I didn't go after Mason because I thought it was okay.
thank you for the explanation.
Then please, Mr. Public Prosecutor, present witness two.
Okay, Miss Araya, please enter the crowd.
Allow Judge Member One to take the oath of the witness.
Bismillahirrahmanirrahim. By Allah, I swear that I will tell the truth
I should the back
and nothing but the truth.
and think of it.
warning Mr. Ataya. When you give testimony in this trial, you must be calm. Give your testimony clearly and resourceful, and you must provide information about what you have experienced, heard, and see yourself. Without any pressure, I will hand over the examination process to the public prosecutor.
Is Mr. Ataya related to the defendant paper? What kind of testimony would you like to give regarding this case?
Sometimes of the victim and the victim in the sometimes condition the problem. After the case, there is no personal relation the involving the anxiety that then was defined afterwards.
Why did you have that feeling for victim and why did you not prevent it when you knew that the victim brothers had told you that he want to meet the defendant?
I had offered to people research for the same that that I
For the system legal counsel, do you want to ask our Pujan?
it's not only Muhammad and requires the reading of the corner, the registration to record the witness statement. Your Honor, from the testimony, it can be confirmed that the defendant by discharge in Article 340 of on premeditated murder that carries a minimum sentence of 20 years imprisonment and a maximum sentence of life imprisonment or death. Article 338 of on murder, Article 339 of on murder, Article 365 of on murder with other crimes. Your Honor, the evidence for the evidence that then when the term time of Article 340 of the estimated moment, which has a minimum character of 2 years. Consequence and maximum character of the life permanent object. Lawyer of but of the evidence they can conclude regarding the limits of the defendant. Suppose the narration report that the defendant comes there because he was brought details. So if the defendant is not coming in as from American or from his foreign natural. Two, it's also known that the defendant has mental problem because the defendant has a victim of domestic violence. And former beds on the result of the mental health that the defendant mental condition was problematic between the police term and person. It would be the capital for the population and will semester in which a person can be held in knowledge. And so people in the but on I was for the student in their personally the student is the ability to be similarly responsible. Three, it can be the opportunity for someone people find it true. Then can be accountable. The end become what like a sort and a sense of mind. The gem my order can to be coming to learn and be adequate for the period of 1 year for ignition. I the one so happy that is there. They both strongly the person who comes and act for which the be always responsible variation of the given in the development of main or private island. And from your work, my coach should have said there, even there to say there to be even a corporate entity. However, training in the second. The defendant was access even though he was in poor mental health. The evidence by not mentioned after the murder. Of course, this certainly can be done in an uncontested. Therefore, Your Honor, we believe that the defendant is still charged under Article 340 of our. Your Honor, this considered some of the objections. For not so it was of familiar was one.
Lawyer, important to remember that the defendant commit act knowingly, which means that illness was not relapsing. We don't need to leave his mental health take care.
Article 340 on premeditated murder. Whoever deliberately and with premeditation takes the life of another person shall be guilty of manslaughter, be punished by death or life imprisonment or maximum sentence of 20 years. Article 305 on murder. A person who shall be punished by a maximum imprisonment of 15 years. Article 309 of the KUHP murder qualifies goods like meats, murder which is for company and preceded by a crime and which is with intent to facilitate the commission of the crime if caught red-handed to release oneself or a participant from punishment or to keep in one's possession property obtained unlawfully shall be punished by life imprisonment or a maximum imprisonment of 20 years. Mr. Mahatma, you are notified that today's hearing is the reading of the court petition. And you are ready to hear that petition.
Yes, it's ready, Judge, sir.
From the result of the fingerprint test conducted at the Casual Hospital, it was found that there was a 99.99% match between the evidence fingerprint sample and the fingerprint sample found on the victim body, and the evidently examined in the form of a solid. First, we wanted the bits of the victim body, the extent of the head, the one that cut into two, total of 4.2 legs that were cut into two for a total of 4, and 20 parts that were cut into 4 bits. Second, all of the body parts that we obtained were already cleaned from blood. 3. The definite fingerprint will form on almost all of the victim who was then inspired. 4. Strangulation wounds will form on the victim necks. 5. Step wounds will form on the victim neck chest when next step wounds, and 4. Step wounds on the victim neck chest consistent of step wounds and blood rubber step wounds. The blood rubber wound was the main cause of the victim death. On the head, when step wounds was found on the front of the hand. 6. A black was included on the back of the hand which was two pieces of bar. 7. Of the hand was in the hand of the dead.
And according to the decision of the panel of judge, it is notified that in there is an objection to this petition. An appeal might be filed on no later than 15 days after this petition is recorded. To the defendant, do you understand this petition? Okay. Therefore, the examination is of this criminal case on behalf of the defendant Mahat is concluded and we declare this hearing closed.
Memang ayo.
Oke, ya, kelompok 3 sudah selesai dengan baik ya. Selamat beristirahat. Ya, saya cukupkan untuk kelompok 3. Nanti di list nama dan NIM-nya.
Ya baik, Ma'am. Terima kasih, Ma'am.
Ya, silahkan kelompok terakhir.
Ma'am, kami melanjutkan kelompok 4. Terima kasih, Ma'am.
Ya,
Ma'am, kelompok kita sudah ready.
oke, ya, baik. Silahkan dapat dimulai. Pastikan tidak ada yang blocking ya. Blocking membelakangi saya tidak ada. Nah, itu kursi yang di tengah boleh dipinggirin, enggak apa-apa. Ya. Oke. Nah, biar dia juga kelihatan. Ya, silahkan.
The cargo take their place. Second, they are expected to symbolically in their respective place during the trials. Third, in the front row, everyone must show respect for the court. Fourth, visitors to the hearings are prohibited from drinking, smoking, reading newspaper, or taking action that may disrupt the proceedings. In addition, please disable communication device. Fifth, anyone is prohibited from carrying firearms or sharp weapons and explosive or tools or objects that can endanger the security of the trial. Who carries them must be stayed in the place provided. Six, everything ordered by the person to maintain order in the trial must be carried out immediately and carefully. Thus, these rules of order are to be observed and obeyed for the smooth running of the trial. The reading of the rules is complete. Thank you. On this day, Friday, December 20, 2024, at 3 p.m., the trial of criminal case number 777 2024, PNS and GPSP will begin immediately. The judge entered the courtroom and the audience is requested to stand up.
version of the smart report, which was clearing the case with the register number 7778B 2024 and SMGTS on behalf of the defendant Anastasia was declared open and public. Public prosecutor, please present the defendant in the court.
Your Honor, allow me to present the defendant.
Yeah, and in virtual, I read the contribution, yes, sir. Hi, the panel of judges will check your identity first. You only need to ask for my patient. Okay, age and date of birth, 25 years old, born in December. Next, June. Occupation, education, master register.
Pursuant to Article 56 of the Criminal Code, the defendant is entitled to be represented by a legal counsel. If the defendant currently represented by a legal counsel,
Mr. I thought you were by my legal counsel.
if it's true that they are legal counsel,
Mr.
counsel, please come forward to give your up. Special power of please come forward to examine the defendant.
By public prosecutor. Mr. Public Prosecutor, are you ready with the indictment? Have you also received a copy? This is your time. You are invited to read out the charge.
Well, thank you, Your Honor. Allow me as the public prosecutor to read the points on the legal, the panel of judge, and also the legal counsel and president. Semangat District Attorney Office for the Justice, the Nobel Panel of Judge, our respect, legal counsel. On our estimate for this one, with case register 777 PB 2024 PN SMG PhD1, the identity of the defendant, name Anastasia Cerita, place of birth Jakarta, 25 years old, date of birth November 90, 100, 90, 1900, and 99, gender, female, national Indonesia, dan Geraha Sunter Pertama, Kompleks Jalan Selat Bangka, Pulau Jalan RTI RW Sumber Dash Makassari, Subdistrik Semarang, Region Selatan. Occupation, private or fashion designer in New York, education master degree. 2. Detention story. One day investigator 4 Desember 7, 2024 to December 10, 2024 to extend by the public prosecutor from December 9, 2024 to December 12, 2024. 3. The enlistment in this one that the defendant Anastasia Cerita, who was a private victim. Enlistment on Friday, December 6, 2024 at 8 p.m. or at least within the month of December 2024 at Cafe Teleposa or at least within the jurisdiction of Semarang District Court, which has the right to remand. Trial at inside this case is accused of committing murder or component of preceded by a criminal case with the intention of preparing executing its execution. The action is followed in the following ways. It is true that the defendant was a friend of the victim when she was studying in America. It is true that there was a meeting between the two of them before the victim, where the defendant ordered coffee because this was known by the witness, an employee of Sentosa Cafe and Perfect. Tim Saki Bianca Widow. When eating the coffee or by Andia, it was known that the victim named Mila had Addis Piani immediately coached and had a seizure until she was rushed to the hospital. Then the victim died on the way to the hospital at 8:30 p.m. It is true that the defendant at the time was conscious, not suffering from mental illness, not under the influence of drugs. Therefore, judging by this, the defendant on behalf of India, Diana Srindra, has set out in the criminal case. Is charged with a single charge of article penal code on premeditated murder, which carries a maximum penalty of death. That's respectively.
Okay, defendants, you understand and comprehend what you are charged with. Defendant. Okay, you will file a memorandum of objection to the person charged in this one. But it's not my responsibility. But it's responsible to the excellent. Has been out. Desember 2024. I also found or both if you are green, and India was also to study of writing survey scanning. We refer to the constitutional court ruling that is can use and evidence without the consent of the investigator. If CCTV is considered as evidence, there is no factor in scanning and putting in the action based on all the above qualities. The defendant is of Israeli expansion and illusion. That is normal view of it is subject without that the panel objects. Consider all the arguments that have been put forward for the state of justice. Basically, that all the panel thank you. In that context.
I don't think so.
Okay. So in order to know the true chronology of this incident, the fourth person's witness who was at the scene of the crime. To the witness, take the witness.
Probably, but we can go on with Well, witness allow us to learn. The witness is the voice for the then the witness follows my words. Melahirkan. Get I swear.
Yes, sir.
And
Yeah, you are.
based on the provisions of Article 100 in paragraph 2 of the Criminal Procedure Code, because the testimony of the ex of the identity. And Becky Adriansha, Press of Good Jakarta, age 4 years, date of birth December 10, 2000, gender male, digital Indonesia, residence Komplek Graha Bunga Asih, Selat Miring Street, June Islam, occupation writer or architecture artist, education master's degree. Do you know the defendant?
The defendant is Frank Okela and I am studying in America. And India and Canada is the major, where I had a different major. But because we were both Indonesian, we often went together in class and Frankfurt.
Explain how the software
They have invited us to have dinner together in the cafe. I didn't think there was any strange. And India came first and asked what we wanted to order. Then Mila said she wanted to stay up late because of the design, so she ordered an ice americano. Her favorite being Chinese porridge. When I arrived, Mila saw the eggs were already on the table and she looked happy. She grabbed it immediately and the door between opened before we arrived at the meal. Saying it tastes more bitter than before. I asked her to sit and I guess it was true. After drinking, she got the remote to swing and asked for mineral water. It was long before she became weak and phone started to come out of her mouth. I panicked and immediately before around take her to the nearest stop. But I remember to set the atmosphere in a cafe suddenly around very tense. Some people started running around looking for help. I didn't see anything strange.
Yes, went to others, right?
Yes, sir.
Or small conversation in the group.
Nothing wrong. Of the time we grew under the incident, there were no strange confrontation at all. I know what Mel and Amelia were talking about. We are open with each other and share our problems and feelings.
Was there ever a conflict that you saw between the two, or the last conversation of an idea?
Nothing wrong. As far as I know, Mila never or said anything bad about Amelia. I also felt that Amelia was not fun to be friends with. If there were conflict, as I recall, there were some occasional difference of opinion, just like in normal friendship. However, I never saw any great argument between them.
Now, is there any result from the prosecution?
Yes, Your Honor. Let me ask the witness a few questions. Thank you, Your Honor. Mr. Witness, how did Anidia when he suddenly relaxed and pumped up as you have described? What was Anidia's facial expression at the time? Did Anidia do anything conspicuous?
When Glenn fell, I was only focusing on Mila. I didn't know what Anindia was doing. However, I looked at Anindia for a while. She looked confused and didn't know what to do. Like she didn't expect it to happen. She also immediately asked people for help. So I didn't think she was doing anything conspicuous other than trying to get attention and help.
Mr. Witness, let me ask again. Isn't it strange to drink to order drinks for a friend who hasn't arrived yet? What is Anidia habit in America?
provide real evidence.
Yes, Your Honor. Therefore, allow the present witness who was at the scene of the crime.
Your case. First, we will leave the suit. The next witness may enter the court.
That is the question. Is it for Mila Makin, Doma, that actually? It is that. The witness has been served, so you're obligated to give a response.
Yes, during the business. And see told me that the tree was worthless. Was on the defendant also went for the jumper, but this is not the question. When it was the concept and often the value. The grass with ice cream, once with the espresso extract, then pour it into the glass with ice cubes and serve it to the person. Which all has the food from the soup. Now, after that, should because the coffee was so strong. For the times were over, no one touched the coffee order than me and the defendant, because my friends were all consuming on the. Without may have sending us use almost again, although I read that. The library books and many which you can see. It's already in the messages. Oh, so, it's probably given, American. It's the convention, also standards.
Your Honor, according to the CCTV, that we took during the making of the ice americano, there was nothing strange done by the cafe staff. But according to the testimony of the cafe staff, no one else but the two of them held the glass before draining. Not only that, according to the first witness, when Mila arrived, she immediately drank the ice americano with the straw prepared by the defendant. In fact, the straw should have still been worked neatly if it had not been opened at all. Is it clear that the defendant who put cyanide powder in her drink? Is it clear? That's all. This branch point to the excuse. This is the concept evidence that I have present, Your Honor. My testimony is sufficient. Your Honor, from the conclusion of the witness who have been present, our team concludes that we will charge and prosecute the defendant for article on premeditated murder with minimum sentence of 20 years in prison and a maximum life or death. That's all.
There, they will follow on, so. The next progress is complete. There is no question, but not. The is that. There is difficult to do, the digital meeting is never first. That's our the but so far. Because, first one way. That is having found, there is something initiated there, so the problem, where the discussion. If the information is gathered. For seven that is not for the perfection, only the distance for the distance. Your case. Second witness may leave her seat. Please allow the next witness to enter. Allow us to tell your effort. The witness is required to say one step forward. Mulai dari kaki, well, swear, then I will. Witness. Okay, when the defense also continue their action. Expert doctor, expert. The teacher is always have see it has know. Also have every acknowledge in skill. See the definition of organ that we want from the head, all part of the body, but the brain and organ stays on the It's never to be taken, they must do. They are estimating of every part of the body, but the so it runs for articles from the body first the market say that the whole body is fat and because of the there is no August and because in this like a workshop between brothers from so it's silent person when like storm is forming it's like storm and in the river but and first so the body acts that was blue this is not that characteristic of someone with particularly blue is because a lot of oxygen this is not how work approaches but this is not body but blue from silent and the soul after that. Why? Because silent does the maybe body to more abundantly. It's a difference between oxygen very and oxygen useless. Not this. Which you will also find the cost of it. How can the person get to whole of sea? However, then person contact with but there was no definition. C was exposed to lightning. Exam is a 50 was needed. Concern there will be a bit of other life there are more present. There are the possibility that the stomach can run the that was mentioned as for for financial second factor design level of some no, not the third gas anxiety generally range from 0.5 to 3 millimeter is flat, depending on individual considering and constructive. However, several organs they are often to be negative percent in of this results. That's not the outside the truth. Instead, the big extent was finding out space second. The other second in the thinking stomach was quite small, even in the liver and other organs in a single complex form. Action complex of second were low. But not because not all of civilized and other something was that because of the big extent is still uncertain. The cost of it can be determined. There's so many lessons.
Ada apa? Aman? Oke. Halo? Kok nggak kedengeran apa-apa? Ada apa? Ada apa? Nggak denger ya? Halo, halo? Iya, ada apa?
Oh, tidak, men. Tidak masuk.
Oh ya, tak kira ada kendala karena kok diam.
Tapi ya.
Oke, ya, silakan. Halo, saya kok nggak dengar sama sekali ya? Coba audionya dicek. Tombol mic itu diklik, kan itu ada kayak segitiga.
Iya,
Coba
men.
diklik, iya itu audionya masuk lewat mana?
Oh, bisa dipencet. Oh, nggak bisa dipencet.
Tulisannya apa?
Microphone array.
Nah, itu diganti ke DV. Ada nggak
ada.
tulisannya? Udah? Halo? Oke. Kok masih kecil ya tadi? Enggak, yang Mbak pojok jilbab hitam tadi ketika ngomong sama sebelahnya saya belum dengar sih. Itu yang Mbak jilbab hitam sebelah. Atau gini aja, halo, gini. Coba Mbak E yang di sebelah sana, kamu ambil HP, kamu masuk ke Zoom ini, audionya dibuka gitu aja. Nah, satu orang aja, nanti audionya bergantian gitu ya.
Your Honor, we also request that you handle this case in accordance with the applicable principle in the criminal field, namely the principle of in dubio pro reo estate in Article 183 of the Criminal Procedure Code. In this article, it is stated that if there is still doubt whether the defendant is guilty or not, then the judge should rule in favor of the defendant, namely to acquit the defendant from the charge. That is all the additions from the legal team. Thank you, Your Honor.
Okay, this is the defense of our pledoi submitted by the defendant's legal counsel. To the public prosecutor, will you file a reply to the defense of the defendant?
Yes, Your Honor.
Okay, for that, would the public like to present it or orally or in writing?
Orally, Your Honor.
Okay, please submit.
Your Honor, with the charts that we have presented, we insist on the charts that we have presented that in the final.
Okay, today's hearing is declared sufficient and that the panel of judges will be deliberate to make a decision on the pleadings from the hearing. With this, the hearing is adjourned for the next 2 weeks. What is the date for the next 2 weeks, class?
January 3, 2024, Your Honor.
Okay, so on Friday, January 3, 2025, there will be a further hearing with the agenda of reading the decision. The public prosecutor, legal counsel, and the defendant are expected to attend the next hearing without being summoned again. Therefore, today's hearing is declared adjourned and closed.
The audience is requested to stand up. The judge is allowed to leave the courtroom. The audience is also allowed to leave the courtroom.
Oke, ya sudah selesai. Tadi sempat tidak terdengar, tapi ya sudah baik. Apa namanya, untuk kelompok ini saya apresiasi ya, kalian menggunakan kostum yang berbeda disesuaikan dengan peran masing-masing. Itu artinya kalian prepare, menyiapkan, melakukan yang terbaik. Saya sebenarnya pengen sekali ikut bergabung, tapi saya flu ya, nanti daripada nularin, maaf sebelumnya, jangan sampai mengurangkan semangat belajar kalian. Oke, sampai bertemu di lain kesempatan ya. Oke, selamat istirahat, pulangnya hati-hati. Oh, tidak terdengar lagi. Ini kayaknya yang punyanya Cahya itu audionya mungkin mic-nya. Oke. Ya, coba dipindah ke laptop, Audionya dipindah ke laptop. Oke, ya. Ya, oke, sama-sama ya, silakan. Ya. Di luar ada rombel hari Jumat deh ya. Ya. Oke, silahkan boleh di live. Ya, boleh dibawa laptopnya.
Ya, izin mengakhiri Zoom, ma'am.
Ya, silahkan.